Assalamualaikum everyone. I hope that you are doing fine there. For today, we are going to proceed with the new chapter under chapter 4, other methods of administrative law review, so called as non-judicial review. Before this, we are going through the substantive law and procedural law. This is where we need to control the power exercised by the public authority, through the judicial review. So if we say that it is judicial review, means that it must go through the process of court, which is High Court. Right? So through this judicial review, we can decide that whether the decision or whether the subsidiary legislation made by the public authority can be challenged or not. Other than we are using the process of judicial review, we can use the process of non-judicial review. Non-judicial review will exclude the court review process. Right. For this chapter, there are 4 learning outcomes that we are going to achieve it. Alright. So at the end of the lessons today, first, students should be able to elaborate on the characteristic of administrative tribunal, ombudsmen and public complaint bureau as avenues for non-judicial review of administrative actions. So please bear in mind that under this topic, non-judicial review, we are going to scrutinize the 3 methods of non-judicial review, inclusive of administrative tribunal, ombudsman and public complaint bureau. Next, students should be able to explain the reasons for the existence of an administrative tribunal, ombudsman and public complaint bureau. And then students are able to discuss the strength and weaknesses of an administrative tribunal, ombudsman and public complaint bureau compared to the courts. And last but not least is students should be able to illustrate the Malaysian Tribunal, Ombudsman and Public Complaint Bureau organizations. As for an introductions, traditionally we know that if we have a dispute between individuals, or between individual and the ruler, all of this dispute will be settled by the courts. And for this purpose, every democratic country has a systematic courts system. I believe that you have learned during your course of Malaysian legal principles, or Malaysian legal system. You have learned the hierarchy of courts, together with the compositions and their jurisdictions. Right? However, the courts today have lost their monopoly in determining disputes and have shared the authority to settle dispute with other avenues in the form of either we have administrative tribunals, ombudsman, or public complaint bureau. Why we need this non-judicial review? Or outside of the court process, because if we as we know, through the systematic court system, there should be a very there are so many backlog cases. So kalau you nak wait for your case to be settled pun, it takes about paling cepat pun, paling minimum pun about 6 to 1 year. So sangatlah lama. That's why we need the other process known as non-judicial review. So the first process we are going to learn is administrative tribunal. A tribunal is a body established by Parliament out of the court system to hear dispute related to administrative matters, not only between individuals but also between individuals and the ruler. For example, dispute between an individual and the ruler, i.e. tax collections by the custom and excise department. And dispute between individuals is determination of the rate of rent between a landlord and his tenant under the rent controls. Normally when it involves civil law transaction. Okay, we will go to the tribunal as well. Okay, there are some features of the tribunal. Okay, according to some authors, there is no specific definition to explain what an administrative tribunal is. According to Garner, any statutory body which has any or all of the following features can be considered as an administrative tribunal. First, it is free from the administrative and makes a decision fairly. Okay, so no person can exercise bias in making decisions for non-judicial review. Okay, so they are free from the administrative functions. And then the decision made by this body is the decision of its panel members, not made by any one particular person. So everybody must share the inputs in making decision, not only focus to one particular person. The decision can be binding on other cases. The procedures adopted in its proceeding are easier and more flexible from the courts. Why it is more easier and flexible? Because this is not based on the systematic court system. Okay, we just follow the procedures of the tribunal. And then its existence is perpetual. Perpetual means forever. It is not abolished after a decision is made. Okay. There are few reasons for growth of this tribunal. First, the increase in function and duty of the administrator. So we know that the disputes faced by administrator, for example, in regards to the tax collection. So in order to finance these activities, okay, tax collection is a standard, and then this has caused many conflicts between the taxpayers and tax collectors. Okay, so since the duties, the functions, okay, increasing, so we need the administrative tribunal to lead the disputes. Okay, second, the weaknesses of the court and the strengths of the tribunal systems. Okay, the procedures pertaining to the court are much stricter, formal, technical, and costly, and this is unsuitable to settle small cases involving administrative problems. So it is advisable to bring a small case to the administrative tribunal. And some of the advantages of tribunal system are first, speed. Okay, a tribunal usually handles small cases, and this lead to speedy solution because they are not bound by technical procedures. Informal. The informality atmosphere in a tribunal proceeding makes parties to the proceeding feel more at ease to come forward to give evidence, and this subsequently is the trial of a case. Okay, so the surroundings is informal, okay, as compared to court system. Expertise. Okay, a tribunal consists of members who are experts in their field, and then it is suitable for trials that relate to specific administrative matters such as tax evaluations, housing, social services, town planning, and others. And disputes that relate to social and economic affairs are not only linked to legal matters, but also skills in certain fields. And cost, in terms of cost, okay, when we bring a case to a tribunal, it is obviously much cheaper compared to a case brought to the court. And this suits with small administrative cases that are tried in tribunals. Freedoms, okay, autonomy are given, okay, to the tribunal. Okay, this is known as an autonomy concept, okay, which the tribunals convince people of the decisions made by them. Okay, they try to persuade people that their decision is very binding upon the parties. Okay, and then it is neutral. Okay, executive will be one of the parties to the dispute, so it will avoid the bias decision. Okay, however, there are also disadvantages of a tribunal. First, in regards to the freedom freedom enjoyed by tribunal is not the same as the courts because the latter freedoms is guaranteed by the constitutions. Okay, court system are based on constitution, but for tribunal is not governed by the constitution, so the freedom is not guaranteed. And then there is still a connection between the tribunal and the administrative. Sometimes its panels are still bound by policies made by the departments, which can cause the decisions to be less objective and biased. And the panels do not have wide knowledge in law that may cause problems in interpreting difficult statutory provisions. Sometimes decisions of tribunal are based only on opinions. And this is because they are not trained with how to decide case based on facts and evidence like what judges in courts do. Okay, so in terms of legal backgrounds is different. And then tribunals do not have to give reasons to all decisions made, and the decisions are not published to the public. Hence, the public may not know how a tribunal reach its decisions. Okay, they will not allocate the procedures how they reach to that decisions. Okay, as compared to court, because court will always give reasons, will always give we call it as a ratio decidendi. Okay, when they decided certain matters. Okay, next we proceed with Friends Committee.